Well, hello and welcome to the webinar, everybody. My name's Andrew Duncan. I'm a barrister practicing at Three Paper Buildings. I specialise in complex care work and private law children work, and I'm here to talk to you today about changing names in the family court. I'm also really pleased to introduce Kam Kaur from the Parenting Apart programme. Kam's a independent social worker and systemic practitioner. She's got 20 years experience working with children and with families, and she's worked across both public and private law with local authorities, the NSPCC, and delivered therapeutic services for children in care. And she's also the training and development lead at the Parenting Apart programme, which is a service that helps separated parents reduce conflict, strengthen co-parenting relationships, and ensure that their child's emotional well-being remains at the heart of every decision that's taken for them. Cam's going to follow my talk, so I'm very much the warm-up act, and I will discuss, hopefully, try and bring to life a recent case that I was involved in concerning changing names within the family court. So let's get started. There we are. Right. So today's agenda, change of given name was heard in December or November, I should say, judgment given in December of last year. And we're going to discuss that and what that case was all about, and in particular, the impact of whether you bring an application for changing a child's name, whether it be full name or surname pursuant to Section 13 or Section 8 of the Children Act, and also the importance really of a proper welfare analysis from the court and also from those representing children, and also the importance of considering Article 8, which you'll come to see was not done in this particular case at first instance. Re-see then, what was the case about? Well, the case concerned, and I should say before I start, if there's any inadvertent reference to the birth gender of the child concerned, that's not me setting out what that gender was. That will be inadvertent and shouldn't be taken as such. But the case concerns C, who was a 15-year-old child, and there had been protracted proceedings years before this particular application was brought. Those proceedings were acrimonious and had resulted in the end a shared care arrangement being made in relation to C. And that shared care arrangement, which subsisted as a lives with order, had been or remained in force at both at the time that this application was brought and at the time that we reached the final hearing. There was no suggestion from either parent nor from the child through their guardian, who I represented, that should change, and that's the basis upon which we proceeded. I should say that whilst that shared care arrangement was in force, it was not actively being used by C. What I mean by that is C was not going for contact with their father or living with their father in accordance with that order, but both parents had considered that in fact it was appropriate for that order to remain so that C knew how much time they should be spending with their father and when they should be with them. Unfortunately, if you've read Re-see, you'll see that the relationship between father and C had become quite estranged, arising from the issues in relation to their gender. The case started with a number of applications, including prohibited steps order applications, specific issue order applications in relation to father seeking the sharing of medical information, and also seeking or prohibiting action being taken medically to bring about any change in his child's gender. But by the time we reached final hearing before His Honour Judge Tolson, sitting in Reading, the CAS report had been published, and that, of course, made changes for the treatment that was available to any child of C's age. That, along with the child's own wishes and feelings expressed to their guardian that they did not in any event seek to pursue treatment at this stage, meant that all of those issues in terms of the prohibited steps orders and the specific issue order applications really fell away. And the only matter that was left to be determined by His Honour Judge Tolson at first instance was the change, in particular, the change of the child's forename. There had been suggestions that the child wanted to change also their surname, but that was not actively pursued during the course of that final hearing, and it wasn't something that the Guardian had been asked to report on. The reason why we appealed it is because, of course, the judge refused the order, and I will set out the reasons as to why the judge refused it. And we had, of course, instructions from a 15-year-old competent child whose views aligned with that of their guardian that they sought to appeal it. We were heard in the Court of Appeal rather than the High Court because, of course, the normal route would have been the High Court from a private law appeal, but it was transferred on a point of law to the Court of Appeal by Sir Jonathan Cohen at the leave stage. Of course, Judge Tolson refused my application for permission to appeal, and we got the permission from Sir Jonathan Cohen. It was then transferred over to the Court of Appeal, and that arose largely out of the use of forename, surname, and name interchangeably in a recent case called Re BC that we sought clarity on. As it transpired during the course of the hearing in the Court of Appeal before Lady Justice King, the Court of Appeal didn't have any appetite to give that clarity from that judgment, and in their view, they felt that it was sufficiently clear, so that the appeal effectively proceeded on the challenge to the lack of welfare analysis, the total lack of analysis in terms of the Article 8 provisions, and also the Court of Appeal setting out a route in terms of forename change and the impact of that. So what was the decision of Judge Tolson? I think it's right to say that he had a very busy list on the day, I recall it, and we didn't start the hearing until the afternoon, which we had agreed would be dealt with on submissions. Both parents were in person, both attended and were entirely appropriate during the course of the hearing. And the judge really started the hearing with a view that whatever he did, if he were to grant the application, it would have no meaningful impact. It would have no practical impact, and he couldn't really see, for want of a better phrase, I suppose, the point, in fairness to him, as to why we were seeking the name change. You'll see from the judgment, and when we'll address it further down in this presentation, that the judge's welfare analysis was shown to be lacking in the Court of Appeal. And the judge came at the case, in my view, and which was the way in which we'd approached the appeal, from a negative application of the welfare checklist. And what I mean by that is I can't really see any reason why I should make why it is in C's interests for me to make any order, but did not then go on to set out that welfare analysis that meant it arrived at that conclusion. There was no reference within the judgment to Article 8, not only the Article 8 rights of the child concerned, but of course the Article 8 rights of the parent who opposed the order, and those competing rights and balancing those rights was missed. And indeed, there was throughout the course of the first instance hearing a confusion, which I hope that we can clarify in this presentation, as to the rights of a child at 16 and what they are in fact able to do. The judge taking the view that the child could resolve all necessary matters in a few short months when the child reached the age of 16. So that's the foundation, really, in terms of what we were dealing with in Re C. I think it's important to really set out, I think this can often be missed, and it certainly required me to look at this in detail. When we're talking about changing a child's name in the family court, there are two routes to do that. One is Section 13, and one is Section 8, a specific issue order application. Section 13 is really a restrictive provision placed in the Children Act, as you know, that prohibits any parent from changing a child's name or removing them from the jurisdiction without the leave of the court, and I say name, I've got to be careful with what I say, surname. Section 13 relates solely to surnames, and that is the way in which it is drafted into the statute. So if the application relates to a forename only and the child is younger than 16, it should always be lodged as a Section 8 Children Act specific issue order application. And that's because Section 13 doesn't bite on a forename effectively. So there is no statutory restriction, but the child is younger than 16. If they were older than 16, then they are, and we see this particular case that we're involved in confirms at previous case authorities, that if they're older than 16, they are able effectively to change their name themselves without parental consent. And that's really, I think, an important point, that if you're dealing with a child in proceedings and there is a suggestion that that child wishes to change their name, it's opposed by a parent, they're older than 16, then in fact they are able to proceed and change their forename without the need for any application. So if the application relates to a surname change for a child that is younger than 16 and there is no lives with order in force, the application should again be made as a Section 8 specific issue order application. If the child were older than 16 and there were no lives with order in force, the child will be able to change their surname without recourse to the court or court application. So when does Section 13 bite? Section 13 bites in circumstances where there is a lives with order in force. And that applies really in terms of any age of a child, because of course a lives with order is not discharged at the age of 16. It will run right through until the child is 18 by virtue of Section 9110A of the Children Act. So if there's a lives with order in force at the time the application is made, then the application should be pursued under Section 13, effectively seeking leave of the court to change the child's name. And that restriction and statutory restriction applies not just to private law scenarios, it applies to children who are the subject of a care order. Leave would be required under Section 33(7), and where they are subject to a special guardianship order, leave again is required pursuant to Section 14(c)(3) to change a child's surname. Important to note, I think, in terms of the unenrolled and enrolled deed poll provisions, which in Re BC, Mr. Justice Poole sets out quite helpfully, which is referred to in Re C by Lady Justice King. There aren't any regulations that govern the execution of deeds poll, and they only apply to an enrolled deed poll. So effectively what I mean by that is the regulations, sorry, apply only to an enrolled deed poll. And to enroll a deed poll for a child of 16 or 17, that still requires parental consent. So when I said earlier in the provisions a child can go ahead and change their name at the age of 16 and 17, they can, but that would be an unenrolled deed poll. It would not be an enrolled deed poll, which would still require parental consent in any circumstances of all of those holding PR. And the view taken by the courts as to the difference really between the two is only evidential and formal to provide proof of the name to organisations who require it. So it will really be a question of discussing with a child whether or not that is something that they pursue. But when we're talking about name changes generally, in the way in which we see them in the family courts, most are dealt with initially as an unenrolled deed poll, and indeed, if both parents consent, an enrolled one can be applied for from the court. If they don't, the child may wish to wait until they are 18 to enrol it themselves or issue a further application. So in terms of RISI, the welfare analysis, and I touched on this earlier, that when I said that a negative analysis was applied by the first instance judge. And what I mean by that is this is the phraseology that was used within the judgment. It was hard to identify any welfare benefit in the proposed name change. And I cannot see any element within the welfare checklist which points toward a change of name. And that effectively amounted to, which was my criticism, the judge's welfare analysis that was provided as a reason as to why the judge was satisfied they should refuse it. Now, interestingly, I recall Lord Justice Baker intervening when I was on my feet in the Court of Appeal and challenging me, effectively saying, well, the no order principle applies. So if the judge has arrived at a conclusion that when looking through within his mind, there is no welfare benefit, then what is the necessity, in fact, to then set out, as I said he should have done, a detailed welfare analysis, because that would be contrary to the no order principle. My response to that was very simple, which was in order to arrive at a view that the no order principle applies, first, of course, you have to, in fact, go through the welfare analysis and conduct a balancing exercise in order to be satisfied that when weighing up that child's welfare, it's right that you make no order at the conclusion. And what we said was that the decision here was lacking with that welfare analysis. So when we're talking about welfare analysis, it is the case, of course, that it has to be a holistic analysis, and the paramountcy principle applies to name change applications. Certain things that we highlighted, and which I would invite anyone considering these types of applications to highlight, are the length of time that the child's been using their chosen forename. In this case, it was coming up to 3 years that they'd been using this chosen forename. Their identity was this chosen forename. And they had identified with socially, through school, and with doctors, albeit they found themselves having to explain why they were using their name in that way, which was they felt embarrassing. None of that really found favour in first instance with the judge. Effectively, the judge took the view that that was a good reason why nothing would change substantially if he were to grant the permission. In terms of purpose of using chosen name, this was an interesting part of this case because the court had was aware, of course, of the child's desire to express themselves as non-binary, and the court felt in this particular case that if it were to grant the application, it would amount to some form of approval of that change in status to non-binary, which the court was not prepared to do. The Court of Appeal roundly rejected that approach by the first instance judge and said that the welfare analysis needs to be much deeper than just the expressions of gender identity, because this particular child had chosen this forename for now a long period of time, and there were additional welfare benefits for them being permitted to refer to themselves as such in a legal sense. The wishes and feelings of the child, not just, of course, their expressed wishes and feelings, their ascertainable wishes and feelings, and also the impact on refusing the order versus granting it. And at first instance, the judge was very preoccupied with the impact of granting the order. And despite me repeatedly making submissions about the impact of refusing to grant that order on this child, that wasn't reflected in my view, in the judgment, which is another strand of our appeal and challenge to the welfare analysis. And of course, emotional harm is tied in with that. In this particular case, and it's important, I think, where you have a child that has sufficient understanding to effectively act as competent, if their views were to differ from that of the guardian, then that carries also significant weight. The Article 8 analysis was well, it wasn't just lacking, it was non-existent within the judgment. Now there, because of those provisions that I've already taken you through in terms of Section 13, Section 33, Section 14, about the statutory protection that is provided by the Children Act to prevent a child, even of 16 and 17, when those orders are in existence, from changing their name. That's been found in Re BC as evidence to suggest, of course, that Article 8, I think it's fairly obvious personally, but Article 8 of the rights of the parents are fully engaged. And that's because the parents, this is the parent's child. They've named their child from birth, and that child now seeks to change that name. Their memories of bringing that child up are associated with their birth name, and those Article 8 rights are therefore fully engaged. Of course, and obviously, the child's Article 8 rights are fully engaged, and therefore there will inevitably be a conflict between the two. When you read Re BC and now Re C together, it's right to say that a child of sufficient understanding of competence of a similar age to the child in Re C, their views and their wishes would outweigh those Article 8 rights of their parent, and that's effectively being determined. I think it's important I before I finish to also reference this, which I haven't put in the slides, but during the course of the first instance decision, the judge gave a preliminary ruling that he would refer to the child concerned by their birth name during the hearing, during submissions, and during any judgment. And the reason that was given for that was that if he were to refer to the child by their chosen name, which we sought on their behalf, then that may be seen as prejudging the issue, and it may be seen as predetermining the issue before the court. And Lady Justice King in particular took some objection to that approach at the Court of Appeal. It was a rather bizarre scenario in the first instance decision where I was referring to the child by their chosen name in all of my submissions on my instructions, which the judge didn't stop me from doing. But the court was referring to the child by their biological name during the submissions, which was a bizarre situation where effectively we were referring to the same child by different names during the course of the hearing. And Lady Justice King confirms in Re C that the Equal Treatment Bench Book provides for and requires a court to accommodate a child being referred to by a chosen name, particularly a trans child. So, which applies equally to gender issues more widely. So that's a helpful authority if you find yourself in a situation where a court is refusing to refer to a child by their chosen name. This authority will assist with resolving that problem now in the future. So that's a real whistle-stop tour of Re C. I think I'm within, yes, I am 25 minutes. I'm within my time allotted. I know that there are some questions, and what we're going to do is answer those questions, both Kam and I, at the end of Kam's presentation that she's going to give shortly. So thank you very much for listening. I'm going to stop my screen share now and allow Kam to screen share her presentation.
Thank you, Andrew. I hope I'm as technical as you, so I'll try my best to get my presentation up. Let me just go into slideshow. Sorry about this. There it is. There's the button. So firstly, I just wanted to thank 3PB for inviting me. Today, I'm going to be talking about how we support separated parents and how our work fits with the legal process to reduce harm and supporting children's well-being. So firstly, I just wanted to kind of give some context to our work, and the programme is currently being delivered across both public and private law proceedings. We receive referrals from CAFCAS, local authorities, solicitors, and also when parents are ordered through the court. We also, in the A12 region, I think it's South Birmingham and Worcestershire, delivered the Improving Child and Family Arrangements, which is known as the IFCA for the CAFCAS, and we are also registered with NAT to support contact. Parents can also self-refer to ourselves. This gives families access to support, whether they're in pre-court or during proceedings or at the end of their court process. The service is offered online and face-to-face, which has made it more accessible and flexible for parents and carers. So our pilot doesn't just sit with ourselves, it is also now being embedded across different local authorities. We have piloted this across Hillingdon, Warwickshire, and North Yorkshire under the Reducing Parental Conflict programme, which is funded by DWP. We've also trained over 150 staff across these local authorities to offer the programme as an early help offer, or when children are placed on a child in need, child protection, or even taken into care. This has helped these local authorities to step in early, aim to reduce long-term harm by tackling conflict before it escalates. We've also undertaken an independent evaluation with Anna Freud Centre. They're one of the leading organisations in improving child outcomes and mental health. And the evaluation of the programme started to show that it doesn't just help parents, it also helps professionals too. So social workers and early health practitioners said that they had better knowledge, felt more confident, better skilled when working with separated families. So for the legal profession, this really matters, as it offers an alternative solution alongside mediation, which takes a relationship-based approach, helping families to find options before families become entrenched, and most importantly, aligns with the principle of the best interest of the child. I won't go into how we've achieved these awards, but these are just some awards that we've received. They show our work is making a real difference to families, especially by improving outcomes for children. I'm going to go and tell you a little bit about why we do the work at Parenting Apart, and this is some of the research that already underpins our programme. Across these major studies, we see the same messages. It's not the separation that affects the child. It is the frequent and intense conflict that puts children at risk. The research consistently shows us that children need emotional stability, low conflict environments, and a strong bond between both parents. So that's where our work comes in. And I think it's really important to point out that only 56% of children in separated parents have regular contact with their non-resident parent. And that was a statistic that was recently published by the DWP. So it's really important where we fit in. So we help parents to develop that co-parenting relationship that prioritises the child, even when they're struggling to find ways to talk to each other. We've also done some evaluation on the programme. So Anna Freud Centre have done the evaluation around the training with the local authorities, but we have also done our own independent evaluation, because we think it's really important to show to parents and professionals the type of support that they need. So our research has already demonstrated that engaging in relational, systemic and trauma-informed intervention, parents spend less time in court, they have a better child and parent relationship. It reduces anxiety and distress for both parents and children, and parents gain focus and tools to make arrangements outside of the court arena. The financial saving for parents is quite huge, but most importantly, the emotional savings for children long term has a real impact. We also see a faster return to contact for non-resident parents, reducing that gap experienced during court proceedings, because there tends to be a significant gap between the non-resident parent having access back to their child. So how do we work with families? We work with families in lots of different contexts. So when families come to us, they're not always in a good place. There is often lengthy legal proceedings, safeguarding concerns, high conflict, or breakdown in contact with the child. Various professionals have been involved. Expert professionals have come in to do psychological assessments. There's been various assessments from CAFCAS. So we don't just look at the presenting issues. We take a step back and look at the whole picture, the family stress points, what is happening for the child, and how the parents are coping. A big part of our work is helping parents to shift their mindset. Many arrive focused on what's going wrong or what the other parent has done or what the other parent is not doing. But we position them as mum and dad, not Mr. Clark or Mrs. Davies. Someone that they need to work with because the child needs both of them. This shift in thinking from ex-partner, from an intimate relationship to partners in parenting, is what helps them to start communicating, making better decisions about their child's best interest. I think this is really important because one of the things we remind parents that separation does not mean that children stop needing both of them. Even though they live apart, they are still connected through the child. What the child needs is consistency, similar routines, and sense of emotional safety, and the feeling that both parents still love them and they're on the same team. We draw from Harvard's research, and that shows how child's brain develops. And we talk this through with our parents, that through early relationships, not just in the first 3 years of the child's development life, but throughout childhood, the way parents relate to each other, even post-separation, has a lasting impact on the child's emotional development. So we begin to help parents take a nurturing, respectful approach. That means showing love, validating their child's emotions, and being predictable across both homes. It is these emotional threads that keep the child feeling safe and secure, no matter where they're sleeping. When parents are in conflict, a child's nervous system is constantly on alert. They're often in flight and fight mode, scanning for tension, listening to tone, thinking, what is that parent saying? How are they behaving? They're looking for every single cue, even if nothing is said directly to them. On top of that, many children are moving between two homes weekly, fortnightly, monthly, during holidays, special occasions, all those times. As adults, we might think it's just a practical arrangement, but for the child, it can feel confusing, unsettling, and uncertain. Imagine having to pack your bags regularly, adjust to different rules, different foods, different bedrooms. That is a lot for a developing mind. We help parents to slow that down and think about these transitions from their child's point of view. Not just what works logistically for them, but what feels emotionally safe for their child. Because when we protect the child's sense of security, we are protecting their development. So how do children learn about the world, about relationships? They do this by watching their parents or their adults around them. Bowlby, who developed attachment theory, reminded us that early attachment does not just shape our children, on how they feel about their parents. They shape how they feel about themselves. When a child experiences inconsistent love, high conflict, or emotional distance, it can leave a mark that lasts well into adulthood. It shapes their relationships into adulthood. How do I love somebody else when I have not felt love? We work with parents to build back that emotional safety and attachment. So what we do is we start to show them how they see each other, not as ex-partners, but as co-parents. That means shifting the questions from do I trust that person to do I trust that person to care for our child? By focusing on the parenting, this starts to create some respect, help build a co-parenting framework that gives the child a sense of stability and emotional security. So when families separate, it is not just the physical setup that changes. It is also the emotional foundation of that child's inner world. Maslow's hierarchy reminds us that children learn and grow only if their basic care needs are met, such as food, a stable, clean home environment, having a sense of belonging, having a sense of family connection and identity. Now, separation on its own is not actually traumatic, but it's the constant and the frequent conflict, the unpredictable moods, and the emotional pressure that creates trauma for our children. We help parents to reduce that by focusing on what they can control: routines, relationships, safe transitions. We also help them to identify who else in their family or their support system can help them when it's needed. Most importantly, we help parents to stop seeing each other as the problem and start seeing what they can do, even separately, to give their child that stability and safety again. So, what is conflict? So we talk about conflict as both a behaviour and a communication of unmet need. We support parents to step back and think about what is really going on underneath that argument. Often it's not about the pickups or the late arrival or who's paying for the school uniform. It's often that parent feeling dismissed, not listened, ignored, undermined, replaced, or devalued. These are real emotions, but when they are unspoken, they come out as conflict. We help parents to understand the difference between constructive and destructive conflict. Conflict on its own is not bad. It is actually how it's handled that's mattered. So with the right tools, parents learn to communicate in a way that reduces stress, not just for themselves, but for their child. Even if they cannot agree on everything, they can still work respectfully. Even small changes in how they respond with both verbal and non-verbal behaviour can make a big difference for their child to feel that they are being loved by both parents. So blame, it's one of the most common patterns that we see, which is understandable because people have come from hurt, fearful, or rejected. Blame gives them something to hold on to. But blame we see as a barrier. It keeps the parents focused on the past and on each other instead of their child. We help them to notice when they are blaming or accusing and not problem solving, and start shifting that entrenched pattern into understanding their own needs and setting boundaries. Instead, one of the ways that we do this by helping them to create shared rules and goals. Things like what is going to be okay and what is not okay to discuss here. What do we do when things get heated? How do we talk in front of the child? What would your child's goal be for you both working together? These boundaries don't fix overnight. But what we do is we make space for something new to happen, space for safety, practice, heal, and letting go. So we don't just sit here and talk to each other. We actually start getting parents to agree on things that they're going to do and how they're going to show to their child that they're going to be doing things differently. So we ask parents, what would your child say if they could speak freely? In my experience as a social worker and working with children in these situations for over the last 5 years, many children do not have the words or the confidence to express what they're feeling because they're often worried about saying the wrong thing which upsets their parent, especially the parent that they're living with. But they show us in other ways through their behaviour, through anxiety, silence, or acting out. So we approach this in a slightly different way with our parents. We get them to acknowledge their child's feeling, like writing letters, co-creating new narratives, asking reflective questions to help bring their child's voice into the conversation. Not to make that child responsible for what's happening, but to give them a presence in a process that affects them. We guide them through a process called mentalization, where they're asked to imagine what's it like to be their child. What is it like to move between two homes every week? What do you think that you need when you are moving to mummy or daddy? What would you like your mom to say to you? And what would you like your dad to share with you? How would you feel when your parents cannot be bothered to say hello to each other nicely? What story are they telling themselves about their family? When they start walking in their child's shoes, they are more equipped to develop an agreement that actually reflects the child's emotional world. We do not sit and talk with parents. We create actions after each meeting with them. We support them to start telling their child explicitly their family life is going to be different. That means no more shouting at handovers, no more arguing over messages, but instead, we are going to be calm and we're going to have respectful in communication that helps our child feel safe again. It's those small changes that are done consistently that builds trust and security for the child. These arrangements help them to think about their child's need now and what's going to look like into the future, not what suits them. It is one of the most powerful parts of our work, helping parents connect with their child's inner world, making arrangements and decisions based on what their child really needs. So, how can you guys help your parents or clients that you're working with? So before I close, I just want to leave you a few reflections. Practical things that you can keep in mind when you're supporting your clients. Get them to think beyond the winning, because if they go into win-win situations, the only person that loses here is their child. Remind them that their child has rights too, and they have parental responsibilities and their role as their co-parent. Ask them what their child might need right now. Make them aware that supervised and formal contacts are short-term, not long-term arrangements or solutions. I think it's really important to tell them that court is a process. It does not fix relationships. Healing and parenting will require emotional and relationship-based support to do that. Suggest early help alongside mediation. We offer free consultations to parents and professionals if they want to talk about their situation. I often tell my social workers that I train, you do not have to be a therapist to make a real difference. I think as legal professions, you are the same. You play a powerful role in shaping how families experience separation. Sometimes the questions you ask or the way you frame a conversation can shift a whole perspective for a family. I'm not able to show you this video. I do urge you to have a look at it. It does give a powerful message from children, and you may want to show it to your parents. And thank you very much for listening to me.